Good day, Crime Talk aficionados. We have another great show for you to start the week. First, Luigi Mangione's attorneys say that the arrest and search of his belongings was illegal and, well, that he should be set free. Kouri Richins alleges that the family trust made payments to witnesses in her homicide case. Donna Adelson's sentencing took place this afternoon. We're going to talk about the case against Fox Sports analyst Mark Sanchez, or we'll see how long he's going to be an analyst. Tyler Robinson thinks he needs to be a sharp-dressed man when he comes to court. A rampage could get this realtor the death penalty. This day in legal history, our quote of the day, and possibly the dumbest of the dumbest dumb criminals ever. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reisch, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. Now, I stress, hit that little bell. I've had several people put in the comments lately that their notifications have been turned off. And so sometimes, I don't know what happens, but YouTube resets something. They hit the clear button. So go back in, make sure you hit that little bell so you get notifications of when we go live or put up new content. Also, you can check us out on any of your favorite podcasting apps as well. Before we get to the docket, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you get a report that is emailed to you while you wait, and it's going to have all types of information, more than you probably expected about anybody. You're going to find out social media presence, phone numbers. You're going to find out if somebody has criminal histories. You're going to find out if they are divorced, married, those little things that maybe they haven't told you when they met you online, swiping left or right on an app somewhere. Go to crimetalksearch.com, check them out, and be safe out there, ladies and gentlemen. It's a dangerous world out there. And also, these things are flying off the shelves. I literally mean it. We got tons of these going out every day. People are signing up to get the CrimeTalk keychain, bag tag, whatever you like it. Crime Talk on this side, Crime Talk on this side. You can't go wrong. $5. Hit the link below. We'll ship it out to you the next day, assuming we have any left. Of course, we'll let you know if they're out of stock. We were giving these away at CrimeCon. It was the best giveaway in the entire convention. And I'll bet you $1 right now. Guess what? Everybody's going to have these next year. That's just my prediction. But also, while you're there, when you go to the merchandise page, guess what? You can also get your baked in Colorado CBD dog treats. That's right. There's the lovely Miss Winnie the Bulldog on there. That's right. You can get an order of those. Sign up. We'll keep sending them to you every month. You can't go wrong with that stuff either. We'll get it out to you ASAP. All right, let's go ahead and open the record for Monday, October 13th, 2025. And the first matter on the docket is Luigi Mangione. That's right. His attorneys say it was all illegal. So the attorneys representing Luigi Mangione, the 27-year-old accused in the fatal shooting of the United Healthcare CEO Brian Thompson, have filed a motion with the federal judge there in Manhattan to dismiss several charges from his indictment, including the sole count that could result in the death penalty. Now, the motion filed on Saturday also requests the exclusion of Mangione's statements to police and evidence recovered from his backpack, citing alleged violations of his constitutional right. Come on, quick quiz. What constitutional right presents unreasonable searches and seizures? That's right, the Fourth Amendment. The defense argues that the law enforcement failed to inform Mangione of his Miranda rights prior to interrogation following his arrest. Additionally, they contend that officers conducted a warrantless search of his backpack, which contained a firearm and ammunition linked to the crime that he is accused of committing. Now, these procedural lapses, according to the motion, render the evidence completely inadmissible in the court of law. Now, as you may recall, Mangione has entered a plea of not guilty to both state and federal charges stemming from the December 4th, 2024 shooting in which Thompson was gunned down upon arriving at a Manhattan hotel for an annual investors conference. Now, the shooting triggered a widespread manhunt across multiple states. The suspect at the time, Luigi Mangione, allegedly evaded immediate capture by fleeing the scene on foot, cycling to Central Park, and then taking a taxi to a bus terminal serving several routes. Police ultimately apprehended Mangione 5 days later in Altoona, Pennsylvania, approximately 233 miles from New York, based on a tip from a McDonald's employee. Now, the defense submission includes a detailed timeline of the arrest, supported by body cam worn footage depicting Mangione seated alone at a table wearing a white mask. Officers initially approached him, citing reports of suspicious behavior and activities after he had been present for about 40 minutes there in the McDonald's. When asked for his identification, Mangione provided a New Jersey driver's license bearing another individual's name. As Mangione began eating, officers instructed him to stand with his hands on his head and to have a pat down. One officer then called for reinforcements, expressing certainty that Mangione matched the suspect's description. Additional personnel arrived shortly thereafter, leading to his detention. Now, Mangione has remained in custody without bail since his arrest, and this most recent motion follows an earlier request by Mangione's legal team to dismiss the federal charges entirely and eliminate the death penalty option, prompted by statements from the United States Attorney General Pam Bondi. And in April of this year, Bondi instructed the New York prosecutors to pursue the capital punishment, describing the act as premeditated, cold-blooded assassination that shook America. That's the Attorney General telling her people, how to go forward. I don't think that's going to get dismissed on those grounds either. Anyway, while the murder prosecution typically occurs in state court, federal authorities have charged Mangione under a statute addressing homicides involving firearms during crimes of violence, and represents the only charge eligible for the death penalty, as New York State does not impose capital punishment. Now, the defense challenges this count, asserting that the prosecutors have not adequately specified qualifying underlying offenses and that the alleged stalking does not constitute a crime of violence under the law. The case has drawn obviously significant public attention, fueling widespread criticism of the U.S. healthcare sector and heightened security concerns among the corporate leaders. Now, investigators discovered ammunition at the crime scene inscribed with the words delay, deny, and depose, a phrase echoing critiques of insurance practices that delay or deny claims, potentially leading to the removal of executives. Now, a ruling on the motion is pending, obviously, and the trial's outcome could influence how federal and state jurisdictions are going to intersect in this particular case. Obviously, the prosecution to file a response in federal court, state court, they usually are wishy-washy about it and say, let's just have a hearing. Now, let's get into the bones of this, so to speak. All right, let's get into the weeds of this particular motion. All right. The defense has filed a motion saying that there was no reasonable suspicion, no probable cause, illegal arrest, failure to advise and Miranda advisements, et cetera, et cetera, et cetera. Okay. There you go. At that point, the burden now shifts to the prosecution to prove by clear and convincing evidence that all the evidence was obtained legally. Well, what's the first basis? There's no reasonable suspicion to approach Luigi Mangione, right? Well, the police officer receives a tip saying, hey, there's a guy that fits the description of Luigi Mangione, the guy wanted for murder. Reasonable suspicion. Cop looks at it. Okay, fine. The police officers then request identification to see who this guy is. Oh, turns out it's a fake ID. They run his ID. Oop, not him, right? They then confirm it's Luigi Mangione. They become quite positive. They ask to frisk him down, right? You can do that for officer safety reasons. That's what they're going to say. They confirm it's Mangione. They arrest him. They then take his bag, open it up, look into it. Once again, they're going to say officer safety reasons why this person is known to be armed and dangerous. They're also going to say, well, we couldn't, just take his bag and not inventory search it because as the police have a duty to protect the property, they don't want to be accused of, doing something. So what do? They open they open the bag. Oop, they find a firearm. Boom, there you go. The question is, could they go into the bag? The police, the prosecutors will argue that everything was completely legal. There was reasonable suspicion. There was probable cause to arrest once they determined that this was in fact Luigi Mangione. They're going to argue that it was an inventory search or inevitable discovery, and therefore the motion to suppress should be denied. Now, obviously, this was supposed to take place in the Pennsylvania case, but Luigi Mangione insisted that he be brought to court, so the matter gets delayed because the feds don't want to send him over to Pennsylvania for the hearing since Mr. Mangione doesn't want to appear via WebEx. So now the federal judge is going to decide what this issue is. Now, in theory, I guess the feds could say motion to suppress denied, and the state could say motion to suppress granted, but pretty unlikely. All right, unless one of the judges just think the other side got it totally wrong. We're a wait and see, okay? Normally, if the prosecution thought that there was an issue with the search and seizure of the evidence in this particular case, they wouldn't be moving forward with the death penalty. Obviously, we'll have to wait and see, but at first blush, it appears as though, based on what we know, that, probably the motion to suppress will be denied. We'll see if I'm right. We'll see if I'm wrong. Next on the docket, Kouri Richins filed some paperwork in her murder case. What is it? So in the legal filing seeking access to financial records associated with her deceased husband's trust, Kouri Richins has alleged that her sister-in-law disbursed funds to individuals involved in her ongoing criminal proceedings. Now, Kouri Richins, who is a resident of Utah and mother of 3 children, she also authored a children's book addressing themes of loss following the death of her husband, which coincidentally she's accused of killing. Anyway, she now faces charges of administering a lethal quantity of fentanyl, Eric Richins, via a cocktail back in 2022. Now, police contend that the act was premeditated to secure benefits from his life insurance policies as well as his trust holdings. Now, the recent motion submitted by Richins' legal team asserted that Casey Richins Benson, Eric's sister and administrator of Eric Richins' living trust, has not fully adhered to a subpoena for the trust's financial documentation. Now, although Katie's counsel supplied partial records, significant portions were retained on the grounds that the Richins lack entitlement to those documents. And Richins' attorneys are requesting a comprehensive detail of the trust's operations, encompassing inflows, revenues, and disbursements to any parties. Of particular interest are reproductions of checks issued from personal or business accounts to persons linked to the inquiry or legal actions against Kouri Darden Richins. In the objection filed with the court, the documents state that Katie's legal representatives acknowledged disbursements to 2 individuals, Brooke Carrington and Matthew Throckmorton, describing them as past and present expert consultants. The response further maintained that the communications with these parties are protected under privilege. Now, Richins' trial on murder charges is set to commence in February of 2026. When you start subpoenaing records, you can do that. And it sounds like legal counsel said you need to turn over certain documents, but other stuff is, in fact, privileged. It doesn't mean it won't be turned over. There'll have to be an argument about it with the court. There'll be a privilege log saying we have these documents, but they're privileged. And then the judge will decide whether they need to be produced or not. Payments to experts, kind of weird that the trust would be paying for experts in the criminal case. Very unusual. But they also could have been retained for consultation as it relates to a civil case as well, which may also be the issue at hand, but we just don't know yet. So once again, I hate to say it, but we're going to have to wait and see. So make sure you check back and we'll have the answer for you. Next, Donna Adelson gets sentenced. Yep, and we knew exactly what was going to take place. So Donna Adelson appeared before the Leon County Circuit Court for sentencing for the 2014 murder for hire case involving her former son-in-law, Florida State University law professor Dan Markel. Now, the 75-year-old resident of South Florida was convicted in September of first-degree murder, conspiracy to commit murder, and solicitation of murder, marking her as the fifth individual held accountable in the scheme that led to Markel's fatal shooting outside his Tallahassee residence. Now, Adelson faces a mandatory life imprisonment without the possibility of parole for the first-degree murder conviction, with additional penalties anticipated for the related charges. Prosecutors indicated that the Markel family that's residing in Canada participated remotely via video conference. His parents, Ruth and Phil, had previously addressed the court in person shortly after the guilty verdict on September 4th. Phil expressed the family's ongoing pursuit of accountability, stating, "We just want everybody and anybody who had anything to do with Dan's death brought to justice. Until that day happens, I won't be fully happy at all, an unhappy individual." Adelson's defense counsel, Jackie Fulford, noted that the defendant intended to deliver a statement during the proceedings, representing her initial direct address to the court. Now, unlike during the trial where she opted not to testify, this opportunity gave her a voice. Fulford also anticipated contributions from several family members and acquaintances advocating on Adelson's behalf. Now, ultimately, the conviction stemmed from a 2-week trial, culminating in a jury deliberations exceeding 3 hours, which affirmed Adelson's role in orchestrating the plot. Now, during the hearing, the prosecution requested life imprisonment on the primary count, alongside 30 years consecutive for conspiracy and 30 years concurrent but consecutive to the first for solicitation, emphasizing the premeditated nature of the offense. They also sought restitution in the amount of $723,000 to cover prosecution costs and debated the inclusion of death points on sentencing score sheets, ultimately prevailing on the mandatory life term. Now, the defense contended the addition to death points, citing precedents from prior related cases, and presented a witness who testified to Adelson's character, prompting an emotional response from the defendant. But the judge, Leon County Circuit Judge Stephen Everett, imposed the mandatory life sentence without the possibility of parole on first-degree murder, along with concurrent terms for the remaining counts, concluding the proceedings and underscoring the gravity of the family's decade-long quest for resolution. Now, we all knew this is what the result was going to be. They could have done it the day of the guilty verdict came out. That's usually the way it is on life without the possibility of parole cases, at least where I practice. Maybe you set it over for a victim impact statement or family member that's not available that wants to speak, but it's perfunctory. The defendant should never say a word because there's going to be an appeal. Reality of it is, Miss Adelson will spend the rest of her life in prison, and she ruined not only her son-in-law's life by having him killed, but his family, and took down her entire family with this plot to kill her son-in-law because she wanted the kids near her. She wanted him not to have custody of this. Are you kidding me? They all deserve the sentence that they got. To hire a hitman because you're going through a custody dispute? Life was the appropriate sentence in this case. Next on the docket, Fox Sports analyst Mark Sanchez was booked at the Marion County Jail in Indianapolis following his discharge from a local hospital. Now, this requirement was mandated by the court prior to his departure from the state. Now, Sanchez, who is a resident of California, had traveled to Indianapolis to provide commentary for the Indianapolis Colts game against the Las Vegas Raiders when he became involved in an alleged altercation with a 69-year-old truck driver by the name of Perry Toll. Well, Sanchez now faces one felony charge of battery, which carries a potential sentence of 1 to 6 years in prison upon conviction, in addition to 3 misdemeanor charges: battery resulting in injury, public intoxication, and unlawful entry into a motor vehicle. Now, according to the Marion County prosecutor, a guy by the name of Ryan Mears, the battery charge was upgraded to a felony after police reviewed the extent of the victim's injuries, i.e. serious bodily injury. Now, the incident occurred early Saturday morning in an alley near the Westin Hotel loading dock, as detailed in the amended probable cause affidavit. Now, Sanchez apparently approached Toll, who was servicing fryer oil for a contracted company. And then surveillance footage captured Sanchez instructing Toll that he could not park in the area and subsequently entering the truck cab without permission. And then when Toll attempted to contact his manager via phone, Sanchez allegedly obstructed him, leading to this escalation in the entire incident. Well, the confrontation intensified when Sanchez reportedly shoved Toll, prompting Toll to deploy pepper spray in self-defense. Toll informed police that he believed his life was in danger, stating that this guy is trying to kill me. He then drew a knife and stabbed Sanchez multiple times during the ensuing struggle. Now, Toll described being thrown into a dumpster and following onto pallets where he perceived Sanchez advanced towards him aggressively, and after regaining his footing. Now, Toll stabbed Sanchez once more, after which Sanchez appeared shocked, turned, and fled the scene. Toll sustained severe injuries, including a laceration that penetrated through his left cheek, contributing to the felony upgrade. So there is a parallel civil proceeding along with the criminal proceedings. Toll's legal representative has already initiated a civil lawsuit against Sanchez and his employer, Fox Corporation, seeking compensatory and punitive damages, as well as costs, attorney's fees, and other appropriate relief as the court may deem appropriate. The complaint alleges that Sanchez's action caused Toll severe permanent disfigurement, loss of function or other physical injuries, emotional distress, and other damages. The suit further claims that Fox Corporation was negligent in hiring and supervising Sanchez, asserting that the company knew or should have known of this unfitness as an employee, propensity for drinking, and harmful conduct. It demanded a jury trial to determine the extent of the damages. So on Friday, the judge approved Sanchez's petition to travel out of state, but stipulated he must first undergo booking and fingerprinting at the jail. Following his hospital discharge on Sunday morning, Sanchez surrendered himself for processing, a procedure that included a capture of his booking photograph. Obviously, this ensured compliance with the court's order before leaving the state. Remember, ladies and gentlemen, if you're charged on a felony, you normally cannot leave the state unless you have permission to do so, which requires a waiver of extradition. You have to be you have to be make sure you've been fingerprinted and all that good stuff. But the most important thing is waiver of extradition, so that if you don't come back, they just come and get you and you can't fight extradition. Unlikely that Sanchez would do any of that, but he had to comply. So obviously, Mark Sanchez is in a lot of trouble, potential trouble in this particular case. Obviously, he's entitled to the presumption of innocence. But I don't know, from the trained observer, it looks like drunk guy gets in dispute with some other guy for no apparent reason. Things escalate. And, well, it was a bad night for everybody involved. Probably going to cost Mark Sanchez a job, lots of money, potentially a felony conviction. However, given the circumstances, I'm sure with the appropriate civil settlement, the victim will probably agree to some sort of misdemeanor resolution of the case. But hey, we'll just have to wait and see. Next, the rampage could get this realtor the death penalty. So prosecutors in North Carolina are pursuing the death penalty against a real estate agent accused of fatally shooting 3 individuals during a violent episode earlier this year. David Lever faces 3 murder charges in connection with the death of Enrique Reyes and the married couple, Anthony and Paula Gribble. The incident took place in January of 2025, and police in Pitt County recently disclosed their intent to seek the death penalty. On January 10th, surveillance footage captured Lever approaching and departing from the residence of Reyes, a 64-year-old neighbor in Greenville. The 2 men reportedly had no prior relationship beyond residing on the same street. And police believe that Lever entered Reyes' home after the victim returned from purchasing groceries and fired multiple shots, resulting in his death. Following the initial shooting, Lever allegedly drove his van to a nearby fuel station where he discharged his weapon from his car. Although no injuries occurred from the gunfire, a witness alerted police, marking the first notification of law enforcement of the unfolding events. Police state that Lever then proceeded to a residence approximately 4 miles away where he knocked on the door without receiving a response. Residents observed an unfamiliar individual leaving their driveway, and Lever is accused of firing into another nearby property during this time period. Subsequently, Lever arrived at the home of Anthony Gribble, 80, and Paula Gribble, 76. Police allege that he entered the premises and shot both victims fatally, and prior to her death, Paula Gribble contacted her son, who resided adjacent to the property, informing him that they'd been shot. The son confronted Lever, detained him at gunpoint while summoning police assistance. During this encounter, Lever reportedly confessed to the son that he had killed the couple. Now, Reyes' body was discovered later that day in his driveway by a neighbor who notified deputies as they conducted a search of Lever's nearby house. The investigation revealed over 50 firearms, including handguns and rifles, within Lever's home, along with additional loaded weapons and ammunition in his car. The Pitt County Sheriff indicated that Lever's apprehension by the Gribble's son likely prevented further casualties, and evidence suggested intentions for additional acts of violence. Now, during his initial court appearance back in January, Lever exhibited disruptive conduct, including profane language directed at the presiding judge upon exiting the courtroom. Reports also noted his history of substance abuse issues, and despite his prominence in the community as a property owner, the events have prompted widespread astonishment among the community. Now, the community is going to focus on honoring the victims. Enrique Reyes served for 17 years in East Carolina University's Department of Biology before retiring in 2022, when he made significant contributions to the faculty, staff, and students. Anthony and Paula Gribble were dedicated members of their church, with their faith playing a central role in their lives. They had relocated to Greenville to be near their grandchildren. I just don't get stuff like this, ladies and gentlemen, and maybe I'm just getting old and tired and cynical of cases like this. But if you're not right and you're just not right in the head, go do what you want to do to you, but don't go harming people that have done nothing to you, your neighbors, for God's sakes. Are you kidding me? I don't know. And I know it kind of goes against the grain as a criminal defense attorney, but what do you do with a guy like this? You're going to spend his remaining days, he's 50 something years old. Go lock him up for the next 20 years, before he dies in the mid 70s, kind of average life expectancy there. Or do you waste your time going on the death penalty, spending the next 20 years fighting it in court? Or do you just let it be? I don't know. Let me know in the comments below. Next, Tyler Robinson wants to be a sharp-dressed man. So it seems Tyler Robinson, the 22-year-old chap accused of turning a conservative speaking gig at Utah University into a fatal fiasco last month, is channeling his inner ZZ Top. Yes, the alleged assassin of Mr. Kirk is petitioning a Utah judge to let him trade his clunky shackles and unflattering prison jumpsuits for, some snazzy civilian attire. When he's in court. After all, who wants to face a jury looking like they just escaped a bad sci-fi flick? Anyway, his legal team is cleverly crafting a 21-page motion filed with the court, arguing that parading him around in inmate's attire, complete with a suicide smock from his last virtual cameo, might just tip the scales for potential jurors. Guilty as charged with bad fashion sense. They essentially quip, watching that such visuals could plant seeds of prejudice, convincing folks he's not only culpable, but downright death penalty worthy amid the global media circus. To bolster their case, they've cheekily nodded to Brian Koberger, the Idaho slasher who got the green light to suit up, get rid of the handcuffs during his pretrial strut, and let's be real. That sartorial upgrade didn't save him from a life sentence without parole for his gruesome 2022 quadruple stab fest. Now, Robinson's attorney insists that this era of viral headlines and endless online chatter, letting their client play dress up, is a small price for preserving that oh so elusive fair trial. Now, facing charges of aggravated murder and more, Robinson could stare down Utah's death penalty options, including the Wild West relic of a firing squad, especially with endorsements from high places like President Trump. Yes, Mr. Kirk's buddy. No plea has yet been entered, but mark this on the calendar. He's set for another courtroom on court on October 30th, and one can only wonder if he'll show up looking sharp or just sharply dressed for the occasion. Ladies and gentlemen, I get it. The defense attorneys are doing their job, okay? And this is a high-profile case and the death penalty, and they want to make sure that they, go through all the due process that everybody's entitled to. And typical, Idaho fashion, Kohberger was allowed to appear in a suit or, at least a white shirt. We also saw it in the Lori Vallow case where Chad Daybell got to show up in his little shirt and tie. 99.999% of all cases, ladies and gentlemen, at a pretrial hearing, the defendant never gets dressed up. They wear their jail garb. Why? Because 99.999% of the time, nobody cares. And even if they do, nobody has said, oh, you know what? We can make him look guilty by doing this, and we're going to prejudice the jury. Now, I get it. And the Supreme Court has said you can't let somebody sit in jail garb and shackled while they're in trial because that makes them look guilty. So I guess the proposition is that they should be in civilian attire every time they go to court, or at least in high-profile cases, maybe. But the question really is it going to change much of everything? It's a murder case. Everybody's going to know that he's in custody. Do you think a jury is that dim-witted to say that somebody's charged with murder on a high-profile case? We never see him go out for lunch with his attorneys. I wonder where he is. Do you think they're going to put the reality together that he's in custody? Yes, of course they are. But yet they want to engage in a legal fiction by saying that we're going to dress him up so that nobody thinks that he is in custody, because that would be prejudicial. He's charged with murder, ladies and gentlemen. That's pretty darn prejudicial. I'm not a big fan of dressing up for anything other than trial. I think it's a waste of time and resources, particularly for the deputies that have to handle that. And when you drop off clothing for somebody, it usually has to be new. As a defense attorney, you get stuck pressing it to make sure your client looks good for trial normally. It takes up time for the deputies to go through it because they have to go through it and search, make sure that somebody's not slipping a handcuff key in there or a weapon or something of that nature to harm himself, or drugs or something. It's a waste of time and resources. So I say motion to appear via civilian clothes should be denied. But we don't know enough about this judge as to what he is going to be leaning upon. So we'll have to wait and see, which we'll discuss a little bit further in the quote of the day. But let's talk about this day in legal history. On October 13th, 1845, Texas ratifies its state constitution, a key step in its annexation to the United States, influencing territorial expansion laws and the Compromise of 1850. And on this day, in 1902, President Theodore Roosevelt threatens to deploy federal troops to resolve the coal strikes, leading to arbitration and advancing labor mediation laws. Yes, ladies and gentlemen, presidents have deployed or threatened to deploy federal troops many times to keep the peace, particularly when the state and local officials were unable to do that on their own. And on October 13th, 1942, the U.S. House passes legislation to abolish poll taxes in national elections. But guess what? It was filibustered in the Senate, so that didn't succeed. But it all that contributed to the 24th Amendment as well. Now, for those who are saying, gosh, Scott, what is the 24th Amendment to the United States Constitution? Well, let's just read it to you really quick. What are we going to do? Let's pull out our little pocket Constitution so that everybody can hear it. Because let's face it, the 24th Amendment to the Constitution does not come up every day, ladies and gentlemen. So let's take a quick gander and read the relevant section. All right. Amendment 24, ratified January 23rd, 1964. Section 1. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representatives in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Remember what a poll tax is, ladies and gentlemen. Like, oh, you gotta do something to be able to vote. You know, the old thing used to be like, how many jelly beans are in this jar? Ooh, you missed it just by this much. You can't vote. Completely illegal, completely inappropriate. And then Section 2 of the 24th Amendment, the Congress shall have power to enforce this article by appropriate legislation. So there you go, ladies and gentlemen. Just another reason why everybody should have a copy of the Pocket Constitution so that you can pull it out and read it and discuss the 24th Amendment like you're a rock star or at least an attorney. And on this date in 2022, a Florida jury recommends life imprisonment without parole for the Parkland shooter. Obviously, a big debate on young adult juvenile sentencing there. And on this date in 2025, the president issues a proclamation observing October 13th as Columbus Day under federal law, designating national holiday and addressing ongoing legal debates over whether it should be Columbus Day or Indigenous Peoples Day. Columbus did find it, okay? And back in those times, it was called, conquest. And to the victor go the spoils. Things weren't always done that were done nicely, but that's just the way it is. And to judge that time period by this time period standards, well, just not right. And let's face it, everybody knew the little, Nina, Pinta, and Santa Maria stuff. You just learned it in school. It's Columbus Day, ladies and gentlemen. How about a legal quote of the day? A good lawyer knows the law. The clever one knows the judge. And finally, probably one of the dumbest dumb criminals ever. Ladies and gentlemen of the jury in the court of public opinion, allow me to present our latest laureate for the prestigious Dumb Criminal of the Day Award. That's right. None other than Walter Freimeyer, the 51-year-old genius who decided the best way to accessorize for a jail booking was with a full-sized thermos, cleverly concealed in his, let's just say, the body's least hospitable storage compartment. How did this all go down? Freimeyer saunters into a Florida county jail, fresh off charges of drug possession and trespassing, because nothing says Saturday night fun like loitering on Amtrak's track with a meth pipe in your pocket. As he glides through the obligatory X-ray scanner designed specifically to catch would-be smugglers, the machine lights up like a Christmas tree. Lo and behold, nestled snugly inside him is his entire thermos, inserted just the day before through what the ever diplomatic Polk County Sheriff Grady Judge termed the exit ramp. One can only imagine the logistical acrobats involved, perhaps a new Olympic event in the making. Well, Mr. Freimeyer's rap sheet reads like a lifelong commitment to poor life choices, including a confessed 28-year-old romance with methamphetamine. But wait, there's more. En route to his new accommodations, he couldn't resist charming the transporting officer with a heartfelt vow: "If you arrest me, I will find you and kill you." When gently reminded that such poetry constitutes a crime, our hero retorted with impeccable logic: "Good, because I'm going to kill you, so charge it." Ah, the sweet sound of escalation. Currently cooling his heels behind bars on a $12,000 bond for a medley of felonies and misdemeanors, Freimeyer had his unconventional carry-on surgically removed at a nearby hospital. Miraculously, no extra charges for attempted contraband importation. Perhaps the authorities were just too busy chuckling to bother adding more charges. Congratulations, Mr. Freimeyer. In a world full of sharp criminals, you have fully, truly earned your spot as the bluntest tool in the shed. You can't make this stuff up, ladies and gentlemen. Thanks for watching. We'll see you next time. And remember, the Constitution matters.